Good day, ladies and gentlemen. I'm looking at the chapter concerning South Africa in Study Unit 6C. In this particular unit, you are looking at the number of insolvency systems coming from developing countries, and my home country is South Africa. Now, if you look at the history of South Africa at some point in its history was a Dutch colony, and it was also at the later stage a colony of Great Britain. So therefore, we have inherited Roman Dutch law, being civil law, as our common law, and we have also inherited certain principles from English law. Hence, we are referred to as a mixed legal system. When we come to our commercial laws, and in particular insolvency and company laws, this part of our law is to a large extent based on English law. If we look in particular at the statutory framework of our insolvency law, we have the Insolvency Act of 1936, we have the Companies Act of 1973 that was replaced by the 2008 Companies Act as from the 1st of May 2011, but certain provisions dealing with the liquidation of insolvent companies in the 1973 Act will still apply. We also have legislation, a smaller type of business, the closed corporation, and you also find liquidation provisions in that particular piece of legislation. And then we have various other pieces of legislation dealing with banks, insurance companies, and so on, and you will also find insolvency principles in those pieces of legislation. Apart from our legislative framework, we also have principles of our common law that will also apply in certain instances in our insolvency law. So if we look at the South African system, the very first point at this junction is that we have a multiplicity of legislation dealing with insolvency law. In other words, we don't have a single Insolvency Act or Bankruptcy Act, as is the case in America or in England and Wales. We have a multiplicity system of legislation. If we look at the functionaries in an insolvent estate in South Africa, we have the Master of the High Court, who acts as a type of regulator. The High Courts in itself, they play a significant role in our insolvency system. And we do have insolvency practitioners being trustees or liquidators, but these persons don't have to have a formal license or a formal qualification to be appointed as such. Their appointment is done by the Master of the High Court, who has an unfettered discretion in this regard. What is, however, very important is that in terms of the 2008 Companies Act, we now have a new dispensation of regulation for so-called business rescue practitioners, and the Company and Intellectual Property Commission also plays a role in relation to business rescue and to some extent in the winding up of companies as well. Now, ladies and gentlemen, if we can go back to our Insolvency Act of 1936. If you want to study South African insolvency law, you always have to start with the Insolvency Act, Act 24 of 1936. The Act is quite dated by now, but clearly it is still in everyday use. Now, what is very important in this particular piece of legislation is that it deals with debtors as defined in the Insolvency Act. Now, debtors include natural persons. It will also include sole proprietors, partnerships, and trusts that operate as business trusts, for instance. And to open up an insolvency proceeding in relation to any one of these types of debtors, you have to bring an application to the High Court, either by means of voluntary surrender, and that will be the case where the debtor, him or her or itself, applies for the sequestration of his or her or its estate, or by a creditor by means of compulsory sequestration. So it takes a High Court application. In both these procedures, there are a number of formalities that have to be met in order to apply successfully. Most significantly, in the case of voluntary surrender, factual insolvency must be proved to the court, and also a very important requirement, namely that there must be an advantage to the creditors. In the case of compulsory sequestration, the creditor who applies can rely on one of the acts of insolvency provided for in Section 8 of the Insolvency Act, and an advantage for creditors must also be proved to the court. So apart from a number of formalities, these are very important aspects that the applicant will have to deal with in bringing such an application. The Insolvency Act also makes provision for a number of consequences of sequestration. There are rules dealing with voidable dispositions, rules dealing with aspects of executory contracts, and there's a most definite structure to administer the insolvent estate. Now, this structure makes provision for creditors' meetings, nomination and appointment of trustees, application of securities, application of the free residue, etc. So there are a number of important aspects of the insolvency process that are being dealt with in the Insolvency Act of 1936. Also take note, in the South African legal system, if there is not sufficient funds available in the insolvent estate to meet the cost of sequestration, certain creditors may be called upon to make a contribution towards settling those costs. This is a very important aspect to look at. If we come to corporate insolvency in South African law, it is quite complex at present. First and foremost, it is important to take note of the Companies Act of 1973 that used to apply until it was replaced on the 1st of May 2011 by the 2008 Companies Act. But the liquidation provisions, especially in relation to insolvent companies, will still apply based on the 1973 Act. So if you want to liquidate an insolvent company in South Africa, you must still use the principles of the 1973 Companies Act. Now, in terms of this particular scenario, you may use the provisions in Chapter 14 of this particular Companies Act, and the chapter makes provision for a liquidation or winding up by means of a High Court application or a voluntary winding up that can be set into motion by means of a member's resolution. Now, if we jump over to the 2008 Companies Act, the question may be asked, what is the relevance as to liquidation of companies? Now, ladies and gentlemen, it is highly relevant because the 2008 Companies Act makes provision for the liquidation of solvent companies. So if you want to liquidate a solvent company, you must make use of the provisions of the 2008 Companies Act. And you can have a look in particular at sections 79 to 81. The procedures are also voluntary winding up of solvent companies by means of a shareholders' resolution or by means of a court order based on grounds provided for by the 2008 Act. What is also interesting, if you start off with the liquidation of a solvent company only to find out that the company is in fact insolvent, there's a provision in the 2008 Act to convert it to an insolvent winding up, in which case all the provisions of Chapter 14 of the former 1973 Companies Act will still apply. What is also very important, and this is why I say this topic is quite complex, if you liquidate an insolvent company in terms of the 1973 Companies Act, you must also take note of Section 339 of the 1973 Companies Act, because it states that the insolvency law will also apply. And in practical terms, it means that where the Companies Act does not provide a certain rule, for instance, to deal with avoidable dispositions, you may fall back on the provisions of the Insolvency Act of 1936 or even on relevant common law principles to deal with that kind of situation in that insolvent liquidation scenario. So that is very important. Quite complex, but it is important for your purposes just to get a sense of what rules to apply in each particular instance. If we come to statutory corporate rescue procedures, it is first and foremost important to note that we used to have the process of judicial management in terms of the 1973 Act and the Section 311 compromise or scheme of arrangement. Now please note, these procedures have been replaced by the new business rescue procedure provided for in Chapter 6 of the 2008 Companies Act. If we look at the business rescue procedure in terms of Chapter 6 of the 2008 Companies Act, the main procedure entails the following. If we look at the initiation of this process, it can be initiated by means of a resolution of the Board of Directors or by means of a court order. When will it commence? In the case of a voluntary rescue by means of a board resolution, it will commence as soon as the company files the resolution at the Office of the Companies and Intellectual Property Commission. In the case of application made to court, in general, it will commence when the order is made. Some consequences of business rescue in terms of Chapter 6 of the 2008 Act. Section 133 introduced an automatic general moratorium on the repayment of pre-rescue debt. Creditors may consent to a discharge of their debt in terms of Section 154. Chapter 6 also makes provision for qualified and licensed business rescue practitioners to be appointed to actually conduct the business rescue. If we look at the duties and powers of the rescue practitioner, he or she must convene a meeting with affected persons, shareholders, creditors, and employees within 10 days of his or her appointment. The Act also allows for the creation of creditor and employee committees, and the rescue practitioner should then consult with these committees. There's provisions dealing with post-commencement financing, and quite a controversial provision is Section 135 of the 2008 Companies Act that provides for a super preference regarding not only for the payment of the rescue practitioner's remuneration, but also for wage and related claims by employees. What's also another quite controversial provision in the business rescue procedure is the Section 136 that makes provision that the business rescue practitioner may suspend or, with the court's approval, cancel contracts, except contracts of employment, which may only be amended or suspended in line with our labor laws, or otherwise by way of agreement with the employees. The rescue practitioner has a duty to investigate all the financial affairs of the company, and certain steps may follow, like the avoidance of transactions and the removal of directors. The main task, however, of the rescue practitioner is to develop a rescue plan in consultation with the creditors, employees, etc., and then to obtain the required approval for its implementation. Now, in principle, the rescue practitioner must look at the affairs of the company, decide if the rescue plan is feasible, draw up the plan, and put it to the interested parties so that they can have a vote on it. If the plan is approved, and once it has been substantially implemented, the rescue practitioner must file a notice of such implementation in terms of Section 152 sub 8 of the Companies Act. And then, well, hopefully the company will be in a position to continue with its business as normal. However, when there is no reasonable prospect of the company being rescued, the rescue may be converted to a liquidation. So in broad terms, ladies and gentlemen, I think if you look at the business rescue procedure in terms of the 2008 Companies Act, you must take note of the highlights to see how the process works and what are the essentials of this particular procedure. What is also quite interesting about this procedure is that we also now have the debtor in possession situation, in the sense that the directors will remain in place as a general rule, but there will also be a rescue practitioner who will actually take control of the company. But clearly the directors will be supposed to assist the rescue practitioner. Another very important section forming part of Chapter 6 of the 2008 Companies Act is actually Section 155 that deals with compromises with creditors, and this can also be used as a rescue device. Well, it also forms part of the chapter dealing with rescue, and it works like this. The board of the company or a liquidator of the company, where the company is already in liquidation, may propose an arrangement or compromise of the financial obligations to all of its creditors or to a member or any class of its creditors. So the proposal can be made, and if it is adopted by a 70% in value majority of the creditors or class presenting and voting, then it will be accepted as having been adopted. But in order to make this adopted resolution a firm new dispensation to deal with the debt of the company, it is advisable that the company should apply to the court to turn this particular resolution into a court order. So this is a very important aspect as well. Since if the proposal is sanctioned by the court, it will become final and binding on all of the company's creditors, etc. So this is very important. Now, in practical terms, some business rescue practitioners say, well, they actually prefer the Section 155 device because they believe they can actually achieve exactly the same with this device as is the case with the main rescue procedure. But this is all very new in our system, and we will see how it will develop in time. Also take note that the 2008 Companies Act makes provision for fraudulent or reckless trading, but we also still have Section 424 of the 1973 Companies Act that deals with this aspect, and it is still applicable. When we come to law reform, ladies and gentlemen, it is quite interesting to note that South Africa started a reform process in 1987 already. Now, the South African Law Reform Commission came up with various reports over the years, but at present we have the 2010 working document, which is in a draft bill format, but it is not a formal bill yet. Now, once this particular document is being reworked and accepted as legislation, and it is not clear when that will happen, the idea will be that the liquidation of companies and what is now termed sequestration of individuals and other debtors will be dealt with by one and the same piece of legislation, except, however, for the business rescue, that will apparently still form part of the Companies Act. Speaking of which, just note that the business rescue provisions of the 2008 Companies Act will also apply to closed corporations, and in practical terms, the liquidation provisions of the company laws will also apply to closed corporations. In fact, since the coming into operation of the 2008 Companies Act, it is no longer possible to register new closed corporations, but we still have many of them in South Africa, so we still need to have a dispensation to liquidate them or even to rescue them in specific circumstances. Now, ladies and gentlemen, that brings me to a very specific topic in South African insolvency law, being the cross-border insolvency rules in South African law. Now, this is a very interesting part of South African law. And first and foremost, what you have to understand is, at present, there is no piece of legislation that you can apply. For instance, let's take this practical situation. You have a debtor, he or she has been declared bankrupt in your country. You are being appointed as the estate representative. You find out that this particular debtor has some assets in South Africa, and you decide that you want to follow up these assets in South Africa. So what type of a situation are we faced with? You're coming from outside, coming into South Africa. It's an inward bound application, and you come looking for the assets in South Africa. Now, let's say your particular debtor has some movable and immovable property in South Africa. Now, in principle and in practical terms, if you want to deal with such assets, you will have to approach a South African High Court and apply for a recognition order. And the interesting thing is that you will have to rely on the discretion of the court based on the principles of comity, convenience, and equity. Because, once again, as stated already, we don't have a statutory dispensation that is in place in this particular instance. So you have to bring a High Court application. Now, what is also quite interesting in this regard is that there are principles of private international law that states if the court where the debtor is domiciled has issued the insolvency order, movable property wherever in the world will vest in that insolvent estate. But in the case of immovable property, the lex forum recitae will apply. Now, these may well be the case, but in practical terms, as stated already, if you come in from outside and if you want to deal with such assets in South African law, in principle, you will have to apply for at least a recognition order. So that is a very important aspect. Now, in the one case that you are being referred to, Ward versus Smith, Inragur versus Zambia Airways Corporation Limited, the court specifically held that it is imperative for the foreign representative of a juristic person to apply for recognition where he has to deal with either immovable property or movable property within South Africa. So there you have it, very important. So first and foremost, if you want to deal with South African assets situated within the boundaries of this jurisdiction, you have to apply at least for a recognition order, and as stated before, you will have to rely on the discretion of the court, but we have a system of precedents, so at least there is some measure of predictability built into the system. If we look at the discretion of the courts in particular, it is quite interesting to look at the remark of Judge Innes in Ex parte BZ Stegman, where the court has stated the following: but on the other hand, in the same court, acting from motives of comity or convenience is equally justified in allowing the order of the judge of the domicile to operate within its jurisdiction and in assisting the execution or enforcement of such an order. The matter is entirely one for its own discretion. So this emphasizes the discretionary aspect to the situation in South Africa, but the underlying motive is comity or convenience. That is why our courts are actually prepared to entertain such applications. You must also have a list. A South African author, O'Brien, has listed a number of factors that courts should take into consideration when they are considering the granting of a recognition order. And you can see another well-known South African author on insolvency law, Alistair Smith, has also added a number of factors to this list. So when you bring an application of this nature to a South African court, you have to establish an argument, and you will have to look at these principles in order to do so. When we look at the effect of recognition, and now this is very interesting. If you want to be recognized as a foreign liquidator or estate representative in South Africa, and if you want to deal with assets in South Africa, you will derive your powers from the court order. So it will be very, very important to spell out in the court order what type of powers you need. Do you want to carry out the interrogation? For how long will your recognition remain? Will you provide security to the master of the High Court? And in practical terms, you will have to do that. How will the order be served on affected parties? You will also be almost like a South African trustee or liquidator, because you will carry out your duties under the supervision of the master of the High Court. And all these aspects must be dealt with in the court order. So this is very important to see to it that your court order contains all the powers that you need to carry out your work in South Africa. It's also very important, if you look at cases like Priestley versus Clegg and so on, our courts will not in principle assist in enforcing foreign tax claims or foreign penal orders like fines for criminal offences, etc. Now this is in line with principles used elsewhere as well. So take note of that. When we come to the situation, you are now the foreign representative. You make application to be recognized as such in South Africa, and the South African court turns your application down. Then the question is, what will you now do? Well, in theory, you can apply for a bankruptcy order in terms of South African law, but first and foremost, you will have to establish locus standi in order to do so, and you will have to meet the statutory requirements as explained earlier. So take note of that. Outward bound request. Now this is the scenario where a South African estate representative finds out that the debtor whose estate has been sequestrated or wound up in terms of South African law owns assets elsewhere. Now the South African estate representative now wants to approach another jurisdiction in order to gain recognition and to attach assets, etc. Same scenario. Older case law in South African law indicated that such a South African estate representative had to apply for a letter of request from a local court at first before approaching the foreign court, but in terms of the decision in Gardner versus Walters, it seems to be that this is no longer the position. What is, however, very important for the South African trustee or liquidator is, of course, that he or she will have to follow the legal dispensation of the foreign jurisdiction. And that will depend on what the rules are. Let's take a few examples. If there are assets in the United States of America, the United States of America has meanwhile adopted the UNCITRAL model law on cross-border insolvency. That is Chapter 15 of its bankruptcy code. So the South African representative will be able to follow those rules in order to apply for a recognition order. If there are assets in the UK, the South African estate representative can either rely on Section 426 of the English Insolvency Act or on its adopted version of the model law UNCITRAL model law on cross-border insolvency. However, if there are assets situated in our neighboring country, Namibia, the South African estate representative will find himself or herself in exactly the same position as a foreign representative approaching the South African court, because Namibia has no statutory dispensation, and he will have to rely on the discretion of the court. Now we come to a very interesting aspect to cross-border insolvency rules in South Africa. I can inform you that we have adopted the UNCITRAL cross-border insolvency law, and it is known in South Africa as the Cross-Border Insolvency Act 42 of 2000. And now you may well ask, but if that is the case, why did you explain this common law dispensation, outside legislation to us? Now, the reason for this is, ladies and gentlemen, the South African legislature has decided to include a designation clause in our Cross-Border Insolvency Act. So in practical terms, it means that the Cross-Border Insolvency Act, Act 42 of 2000, will only apply to designated countries. And the Minister of Justice must designate countries to which this act will apply, and up to now, no other country has been designated yet. So in all practical terms, this act is not in practical operation yet. Should our Minister of Justice decide tomorrow that he or she will designate England or Namibia or China or whatever country, the Cross-Border Insolvency Act will apply, and a foreign representative coming from the designated country will then have the benefit of relying on the provisions of the Cross-Border Insolvency Act rather than the approach as explained to you a while ago. Now, there are a number of advantages if the Cross-Border Act will apply, and I think the most important one is that the estate representative coming from a designated country will have a statutory locus standi, a right to come and apply for recognition. So that is very important. Otherwise, the Cross-Border Insolvency Act follows pretty much the same wording, etc., of the UNCITRAL model law. And since you have dealt with the cross-border law already in other jurisdictions, you should not have real difficulty to deal with this in the South African situation once this act comes into operation. But for your purposes, the important thing is to look at the designation situation and its effect on the implementation of the South African version of the UNCITRAL model law. Right, now, ladies and gentlemen, towards the end of this part, you will find a summary of some of the case law on cross-border insolvency law. Some of it has been discussed as part of the text as well, and you can have a further look at those cases as well. I thank you.